Hello, my name is Chauhan. I am the mentor in the Angel Mentorship Group, and this video is prepared for the active members of the group who work with me almost daily between 5 and 7 in the office. And then there is a larger group of almost 270, 80 people in the Facebook who watch these videos along with the people inside the group in different legal topics that I deal with based on my experience of the practice in every single day. So you'll be watching more videos. Keep an eye on this program, Angel Mentorship Group on the Facebook, and ask your friends to join. But today's topic is I had a meeting with an articling student yesterday, another lawyer, and here is my observations on the articling that I have done for several people in my group, which I want to explain to you actually how the articling in my office works. So if you look at the requirements of the Law Society in terms of what the Law Society would like you to learn, a typical articling student would learn, I will read it out to you, the following competencies as it is called actually: professional responsibility, interviewing, fact investigation and legal research, drafting and legal writing, planning and advising, file practice management, negotiations, advocacy, transactional advisory matters. And these are the issues that, as the headings that the Law Society wants a principal to show to the articling student. So now I think what I finished just one articling student, and when I reviewed what I had done with her, which gave me the understanding of what I had done for her in trying to prepare her for her practice. So when I article, unlike most law firms, I'm not preparing the students to work with me as it happens typically. I think the students in Ontario are basically in the schools, they get the impression that the way to article is to go downtown, and then if you article and you're a good student, you'll be selected to practice with the law firm. You become an associate, and then a junior partner, a senior partner, etc. So I think in the way we prepare in the suburbs, the student is give certain number of skills to launch your own practice. So let me just give you an examples of the different things that I would like the students in my group to learn, and which I have done in the past very successfully. We've launched about 10 lawyers in the last 10 years and about 5 paralegals, and the skills that we try to provide to them are roughly the following. And I'll try to summarize the skills, and then anybody interested can join the group or even connect with us, and we'll set up the learning program for you, and or on another law office where we can improve on the ability of the student to learn different skills than the core skills that enable the lawyer to function. So just to give you a few examples, lawyer-client relationship. You see, I think the assumption when you come out of law school is we're not doctors where we have a guaranteed patient base or client base. So we're in a private enterprise advisory system with competition, and where how do you deal with the client will determine in the long run who will come to you. So your image, the way you relate to them, and how you do different things for them will make a fundamental difference. But very little is taught in the typical articling or even the schools on the client relationships. And in particular, actually, in a lot of the students that I have trained have no clue about how to bill a client, which is very fundamental if you're dealing with a client. And then if you article downtown, you think that you can just clock the time and send the bill to the client because you're the lawyer, and the client has to pay the bill because you spent the time. So I think it takes time for the new lawyer to recognize that the client in a suburb are not able to pay the fees the way you are maybe doing in a big law firm. So I think that's something that I will deal with more. I did one video a few days ago, and I want to just talk about a few other topics that are examples of what is missing in the current articling program, as well as in the way we think of articling students and how we prepare them to launch their own practices. Another one is the opposing counsel relationship. You might, if you start into practice and there is a counsel on the other side, most of what we do in the common law system is adversarial, including real estate, including litigation, but litigation is the real highlight of how we use the confrontational model in common law to resolve our differences, if you like, in the courtroom. So opposing counsel relationship becomes very important because you'll get a letter from the other side. I want my answer in the time limit. And I think the tone of the letter would be, I will conduct the relationship and you will follow the relationship. I think so at that time, the knowledge of the rules of practice and your substantive law and procedure and your confidence makes a fundamental difference in how do you manage the relationship. So I think I'll be talking more about that issue with the students and those interested to deal with that question of the opposing counsel relationship. Actually, it's very fundamental in litigation, but it makes a big difference in other areas of law as well, because we do everything in the common law, including real estate, by the adversarial system. You have a vendor, you have a purchaser, you have requisitions, and you can't agree on something, and you have a confrontational system to resolve the problems. So I think the other one that I would comment on is the cause of action. When we learn a cause of action and you put it in the statement of claim or a defense, the precision with which you need to write that cause of action is very fundamental, because you have to identify the cause of action and the damages, and that ability to use the right sentences to identify the cause of action is fundamental. And it seems that in the students that I've dealt with, that seems to take time. Too many words are used, and the precision of the words to reach that understanding is very fundamental in the discussion, submissions, and the drafting, etc. And the paralegals, if I may say so, have a bigger problem in terms of doing this thing. So I recommend to paralegals in our group that they feel free to discuss with the lawyer the cause of action or research. So one group that I'm aware of, and we did a seminar with them, and their system is that they just delegate the job to some outsider and pay them the fees to do the research and give it to them. I personally think that you should use the opportunity to learn it yourself, or have a lawyer in your team that can give you the direction and solve the problem at a practical level. If you don't have anybody, feel free to join our group, and we'll help you develop that ability to identify the causes of actions and deal with them in your pleadings and in your submissions in the court. The practical problem solving. I think although we are in the common law system, in adversarial system that evolved around barristers and solicitors in England, we should not lose track. So the students that I see graduating from university, and then in the group, we have to then retrain them to understand that all the answers do not necessarily given in the legal system to answer. And very often when you frame the question as a claim, the practical way to solve the problem is not necessarily in the rules of procedures and the cause of action alone. It's good to be able to identify the cause. Let me give you a practical example I'm going through right now. If you have a partition action, the partition action will say, sell the property, divide the assets. If you want to solve the problem, you can offer to the other party, look, if you want to mortgage the property and give out the interest to the applicant, then you have solved the problem. But I think if you ask the court that we want to do a mortgage, the judge can only deal with the sale of the property through a receiver appointed or an agent that you agree on. But in terms of the variables you can go through in a commercial sense to set up a mortgage arrangement are not easily conducted in that confrontational litigation system. It's just one example. Another example I can give you is that we had a shareholders dispute in which the dispute was related to one company, and therefore that company was having no assets. So if you form another company, then there is no longer a litigation that you can do. So all the specialists in litigation concentrate on litigation, but forget that we have even a corporate law and other arrangements that you can make to try to basically resolve the issue outside of the arena of litigation. Next one, how to bill a client. I think that even the letterhead, you should use a letterhead. Should you do it bill by the time? Those things are never discussed in the schools or even right up to the bar admission course and in the articling. So, but in the articling, you'll see your principal showing you the letterhead and you get some idea how it works. Effective letter writing, actually. I think that we feel that because we've done a couple of degrees, including law school, etc., that we have a command of the language sufficiently to express our point of view in a letter. But I think that if you want my experience of almost 45 years now, in litigation, I was a deputy judge for about 24 years. My view is that your letter has possibly a very powerful effect because you can not only use the legal jargon, but you can also appeal to the other person's sense of justice and emotion sometimes to try to resolve the issue. So how do you write the letter is very, very fundamental, actually. Other thing, actually, how do you launch your practice? Every time you meet a client, you advertise, you write an article, you do a lecture. There is an image creation that helps you to launch your practice and create your client base on your own. So whole practice in a private enterprise professional system, your ability to attract the client and launch your own practice is fundamental. And then, of course, if you launch your own practice, the question is, do you know how to administer the office, your cash flow, your accounting, etc.? So one of the topics that is very fundamental is that daily, if you have a busy practice or even starting a practice, you could end up spending $30,000 to $50,000 leasing premises, buying the equipment, and wait for the client to come, and you don't have a client. So what are you going to do? Actually, you spend about $100,000 to get to the point of being called to the bar, but you don't know how to launch a practice. So that skill is very, very fundamental. In typical articling, nobody talks about how to launch a practice. So in our situation, what we do is to sit every single day in every file, how to communicate with the client so that he is happy and refers more clients to you. And I help people write the articles, and those people listening and would like to write articles, we encourage that. I'll print your name also in several magazines that we are connected with, where we can publish your articles. The other thing to recognize in the articling and your training is to understand that we are in a common law adversarial private enterprise advising system that must be understood very, very carefully, because all the rules of practice and rules of conduct are governed around that arrangement. And it's not like civil law, which is inquisitorial, where the judge initiates and wants to know the two different sides from his initiative. In a common law, it's very important to recognize that we are asserting the client's right, trying to obtain the consent of the other side if we can. Most of the time, because of the way the claim and the defense works, we are always confrontational. But I think that if you understand the system as a whole, we should recognize that we are in a problem-solving arena. We are first there to solve the problem with the client in the society rather than make just our income by creating more work for ourselves. So you should have a focus on the solution of the problem for the client rather than your own interest. It is written out all in the rules, but in practice, what I observe is that the lawyers are busy trying to figure out how to get better and bigger clients. But I think that we cannot forget our primary duty. So then the courtroom hearings, no training provides you directly in the school how to speak up in the courtroom. Each courtroom, each country, I've called to the bar in several countries. In my experience is that each jurisdiction carries its own culture. For example, in Canada, the judges, I was a deputy judge for 24 years, and I think you know that if you give too much damages on the punitive damages or general damages, I think the person losing the case will take it to appeal. And therefore, the culture of the society, we are conservative in Canada. If you're in the US, you can go, one of the members of a group just started with me, is a US lawyer in Florida, New York, in New Jersey. And I noticed that there the jurisdictions are more liberal, if you like, in terms of granting damages. So you should know the courtroom culture, how to stand up, look at the judge, how to look at the witness, how to show an exhibit in the courtroom. But none of this is taught in the school. It's important that you figure it out. And if you're articling, you should make a point of getting to know these things. If your principal is not showing, feel free to watch our videos. We will show it to you. next is the cross-examination. How do you cross-examine, actually? I just trained a lawyer, first time to go and stand up in the criminal court, and it took some time to figure out actually how to train somebody. You ask a question, get a fact, and you know that you have evidence to the contrary, and you frame the question that shows to the witness and then to the judge by framing the question that you have a different point of view. So all these things are interesting. Join our group on the Facebook, and if you want to work actively with us, you can do it also. We also have members now who are abroad, and a number of things that we do as lawyers is in common with many of the jurisdictions. So we do want to have coverage around the world. We now have members outside of Ontario in different provinces as well as different countries, and we want to assemble the ideas so we help you enhance your practice. Hope to see you again. Thank you.